Can I lose my home if I file bankruptcy? All right. So if you want to keep your home and you file bankruptcy, can you lose it? This would be your first, your rental property, et cetera, et cetera. Now, these next series of questions are going to be a little more substantive, but it's good stuff. It's stuff you really need to know. All right. It depends on the amount of equity in your home. If you file bankruptcy, if you're going to lose it. All right? Let's talk about it. All right. As a general rule, there are exceptions. When you file, you can protect up to $75,000 in equity. All right? So if you file bankruptcy, and I am a bankruptcy trustee, and it's my job to take your stuff and sell it. That's my job. All right? I have to think, okay, what am I going to do? What's the analysis I'm going to go through to figure out whether I'm going to sell your home or not? All right? And this is the analysis I go through. And so when clients come to me and they have $150,000 in equity, but $100,000 in credit card debt, and they say, I want to file, we'll say, well, what bucket do you fall in? Remember the 3 buckets? Good candidate, you should file. Bucket 2 is, you know what, you're not a good candidate. Bucket 3 is a maybe. So we're going to talk about what bucket these folks fall into. So the general rule, we can protect $75,000. If a trustee is going to sell your home, generally speaking, it's going to take about 7%. That 7% is real estate fees, because they have to hire a real estate agent to do this. And we typically add about 1% for various other administrative fees. All right? So those are the 2 components. So what we'll do is we'll figure out, what is your home worth? Let's just say it's worth $500,000. All right? So 7% of $500,000 is $35,000. So you add 75 plus 35 and figure out whether there's enough equity there. All right? And we'll do a math problem in a second. So can't get away from math. Value, though, is huge. Really, really important. The value of the property is not at the time you file. The value of the property is whatever value it might be until the bankruptcy is discharged. I'm going to give you an example. I had a client who had a very kind of unique home in Huntington Beach, in the harbor, beautiful home, and we did an appraisal because she was really concerned about her equity. And the appraisal came in at X. All right, and this was just when the market started getting really high. All right, well, her appraisal came about mid-7s. We filed bankruptcy. A month and a half later, the home, like 3 doors down, sold for $1 million. All right, so my trustee said, your home's worth $1 million. I'm going to sell it. We're like, whoa, no, that's not worth $1 million. So we tried to communicate to the trustee why that home was somewhat of an anomaly and why our home isn't worth $1 million. Our home is really worth $750,000. And that discussion went on and on and on to the point where we ultimately decided to settle the case. We paid X number of dollars as opposed to the trustee selling the home. The problem, though, was at the time she filed, and we had this, I would say dispute, but ongoing conversation with the trustee, several months later, and values are going up and up each month. So that's the problem. It's once the bankruptcy it's once it closes, or once you get the discharge, that's where the value is cut off. So you got to be careful there. So if you represent a client, say, don't worry about it. You have $50,000 in equity, or even $75,000 in equity. Well, a couple months later, that 75 might be 100 or 125. So you got to be very careful. All right, let's do a math problem. $50,000. You have a home. You represent a client whose home is worth $500,000. All right. A mortgage at 625. So you have no equity. It's absolutely no problem. No problem to file. Because remember, the job of the bankruptcy trustee is to take your stuff and to sell it and give it to the creditors. So there's nothing to sell. If there's no equity to get out of the home, they're not going to do it. I've had clients that have had 2, 3, 4, 5 homes, all underwater, even with renters in them, generating money. And the trustee says, I'm not going to touch it because there's nothing to sell. So they file, and they keep their 3, 4, 5 homes. with no legal obligation to pay the debt. All right? And so it could be very good if you want to keep it long term, or they actually keep the renters in there and they don't pay the mortgage and all that stuff. So, but the bottom line is you look at equity. So when is equity a problem? Let's talk about that. All right, so in this situation, we have something a little bit different. You have a home that has a market value of $600,000. The mortgage is $350,000. Then you go through the math. Well, you have $75,000 in equity that we can protect. You have selling costs of about $42,000. I threw in taxes, just there might be some tax arrearages. At the end of the day, you add that up, that's $465,000. So you take $600,000 less $465,000, and you have equity of $131,500. This would be a client I would say you don't want to file bankruptcy. Yeah, I literally had a client come in about 2 weeks ago, a gentleman. He had 2 homes, and one home he had like $275,000 in equity. Kind of unique in this type of world these days. But he had a lot of credit card debt. And I said, listen, if you file bankruptcy, you're going to lose your home because you just have way too much equity. So that's the analysis you go through if someone wants to sell their property and they're considering bankruptcy. All right? Because what you don't want to do is represent a client and they file bankruptcy and then the bankruptcy court sells their home. That's not a good thing. So any questions about that? Yeah.
Does a trustee do an AVM, or do they actually do an appraisal?
Good question. What a trustee will do is they'll send out an appraisal, an appraiser. They'll go out there, and he'll appraise it. And like the house that I talked about in Huntington Beach, their appraiser, the bankruptcy trustee's appraiser, he did what we call a drive-by, all right? And the home was, like $850,000. We're like, well, no, you haven't seen the inside of the home, where the client hasn't done a lot of maintenance work because they hadn't had the money. There's it wasn't trashed, but it was in need of a lot of TLC. So what we did is we took pictures, and we had a general contractor go in there, and he said, here's the list of problems. Oh, by the way, there seems to be mold as well. So we just kind of gave the trustee a true story of what the facts were, and we're ultimately able to resolve that case with, it worked out. And the good news is that the client's home now is worth, well in excess of that $1 million, which is really good. So it worked out pretty well for her. A good question. Yes, sir.
Same scenario, but they have a rental property with equity.
Mm-hmm.
Or actually, yeah. Actually, that's the same scenario. The scenario before, there was no equity. The primary resident was equity in the rental property.
Mm-hmm.
Would that fall into no?
Good question. So the one distinction in this analysis versus a rental property is that $75,000. All right, I'll take that back. That you can only use that once. Yeah, you can only use that once. But it could be primary, or it could be even a rental property. Yeah, you can only use it once. But the key thing is this: if you have multiple properties and there's no equity, or let's just say the equity was $50,000. I'm sorry, if you went through that analysis and there was no equity, you're fine. It's only if you go through that analysis and you have equity, that's when the problem comes up. You have to think about what you're going to do.
Isn't the $75,000 a homestead or no?
No, it's different.
Bankruptcy.
Bankruptcy.
Oh,
Yeah.
So don't they get an additional $75,000 from the homestead?
Yeah, we're going to talk about homestead. This is different.
Oh,
Yeah, this is different.
it doesn't get into the bankruptcy.
Yeah, the homestead exemption relates to judgment liens. Doesn't relate to secured liens. Yes, ma'am.
I'm thinking that there was a difference of the $75,000 over age 65.
Yes. No. Well, good question. Remember, there's nuances to this. Yeah. Depending upon your age and your marital status, that $75,000 can change. Yeah, it can be higher. It can go up to $100,000 and ultimately up to $150,000. So, and there's, but we figure that out before we do it. So, but most folks, it's 75, but it can change. Question. Yeah. So, all right. Okay. So that's basically the analysis. But the key thing to remember is no equity, no problem. You could have 10 homes. Doesn't matter. All right. So, okay. All right. Now this is kind of a related question. Can I buy a home, then file bankruptcy? All right. Let me give you a classic example which just happened to me. Client had a bunch of money, and she had to file bankruptcy. She came through kind of a nasty divorce, a lot of debt, and so we wanted to be able to take that money that was in her account, which, remember, money in bank accounts, savings accounts, that is what we call a non-exempt asset, meaning that they can take it from you. Not a good thing. There's also exempt assets, and we'll talk about that distinction in a second. So we took what we call a non-exempt asset, money, and we dumped it into a home. And we figured out how much of a down payment should she have to go through this analysis that we just went through where the bankruptcy court couldn't do it. They couldn't touch it. So in that situation, we bought a home. We had a pretty good down payment. With that analysis, ultimately, she filed bankruptcy a couple months later. It was absolutely fine. I was a little worried, admittedly, because the home values were really going up. We did this analysis, but so you can still do that. But what that is you're converting what you otherwise would lose, and you make it what we call a non-exempt asset, and you convert it into an exempt asset. All right. The guy with the Porsche, that's what he did. He took his expensive Porsche, he sold it, all right, and then he took that money and we converted it into into an exempt asset the bankruptcy court ultimately couldn't touch. So bottom line is, if you're representing a client that has a lot of credit card debt, this is an option. The reality, though, is a lot of folks who have this type of debt have a very low credit score. This particular client was different because the debt was owed to professionals, accountants and other attorneys and whatnot, so that didn't per se show up on her credit report. So she still had really good credit, she just had a bunch of other debt that we had to get rid of. So that is a possibility as well. Yes, sir.
Student loan, is that exempt from DK?
Student loans as a general are not exempt from bankruptcy. You have to pay that. There are some general rules that you can get rid of that debt, but as a general rule, they're not dischargeable in bankruptcy. And there are other types of debts that you can't get rid of. But you can get rid of tax obligations, tax debt, state and federal, in bankruptcy. But it all relates to timing. It has to be old enough. However, let's say you own a business, all right, and you didn't pay your fair share, you didn't pay your share of the Social Security, all right? And all of a sudden your corporation owes $30,000. And you are what the IRS calls as the responsible party. You have that obligation on behalf of the corporation to make sure it's paid. Well, that type of debt is not dischargeable in bankruptcy. You can't get rid of it. You can settle, and that's what you got to work towards. And the idea is that the IRS, it says, listen, you are the trustee. You have the obligation to make that debt and to make that payment. And if you're not gonna do that, if you're gonna keep all the money and not give it to the government, then you don't have the privilege or the opportunity to get rid of the debt in bankruptcy. So yeah, you got to settle. It happens a lot too. Yes, ma'am.
Do you have a list of non-exempt, assets for bankruptcy?
I'm sorry. One more
Do you
time.
have a list for non-exempt?
Do I have a list of assets that are non-exempt? Not with me. My suggestion is twofold. If you go to Google and type bankruptcy non-exempt assets, and we're going to talk about what it is, because really this is the deal. You have non-exempt assets, stuff you can't touch. It's a general rule, 401ks, retirement accounts. Those are things you cannot touch. Then in bankruptcy, you have assets that have built-in exemptions, meaning that if you file bankruptcy and you have that Porsche, all right? We're talking about that Porsche a lot. That might be, it's paid for and it's $30,000. Well, if you file, you get something called an automatic exemption where you automatically protect about $5,100 of equity in that Porsche. So now, previously you owed $30,000, to keep that car, you'd have to pay the trustee $30,000. But you have an automatic exemption that protects about $5,000 in equity. So now it's not $30,000 you owe, but $25,000. And there's other things we do that we can protect other assets. But we'll talk about what that is. So it's a good question. But really the idea, the things that are a exempt asset is done for a public policy. So I don't mean to keep picking on Len, but if Len filed bankruptcy, which he's not, he hasn't talked to me. Yeah. But if he had $250,000 in his IRA, the question is, should folks who file bankruptcy lose that money? And as a matter of policy, they say, you know what, no. Bankruptcy is designed fundamentally to give you a fresh start. And if you're going to take away all your stuff, that's not a fresh start. That's debtor's prison. Or pretty darn. Yeah, it's not right. So certain stuff you can protect.
So you could load up your IRA with your cash before you file?
Yeah, some folks. If I have a client, that's a good question. If I have clients that have excess cash, and we need to be able to do something with it, right? Happens sometimes. Yeah, well, it depends on. It depends on. Yeah, there are limits in which you can put money into your retirement account. You can put extra, and there's penalties involved. But that is a way that we, on occasion, deal with clients who have extra money and convert something that would be taken into something that cannot be taken. So yeah, we do that sometimes.
There's a tax on the overage.
You do.
You can't protect the amount over what you're allowed.
Exactly.
You can protect it from bankruptcy.
Exactly. So, and the issue in that situation is that the bankruptcy trustee would ask you, well, let's just say you have a Roth and it's limited to $5,000. You put $10,000 in there. So you had to pay a penalty or whatnot. The bankruptcy trustee may say, well, you took that extra $5,000 and you put it in there and that was improper, so I'm going to take it back out. So that's the fight. But we look for opportunities to put monies when needed. We just have to try to convert it. So you have a type of retirement account that allows you to dump more money in. We do that, definitely. It's a good question.
What is the time frame, in other words, if you were to do something like that? How many, is it 3 months, 6 months before filing? In other words, that they look back to?
Right, this one's.
Yeah, okay, it's a good question. All right.
You said earlier 6 months they pull our data.
No, the 6-month deal was for the means test.
Okay.
Whether you qualify for a Chapter 7, you look at your income over the last 6 months, as opposed to anything longer.
Does that include all the tax, the IRAs and the Roths and everything else?
No, so it's a good question. When you transfer assets, all right, from either to a retirement account or to a person, all right, you have to ask two things. What did you transfer and who did you transfer it to? Okay, so Len, back to Len. I'll pick on Jim in a second. So Len goes, I'm going to file bankruptcy. I'm going to transfer my Porsche to my colleague Jim. All right, and if they don't have necessarily a family relationship, or they're not really, on a very simplistic level, really close friends, the look-back period for transfers is 3 months. All right, and so if you transfer an asset within 3 months, it's deemed what they call a fraudulent transfer, meaning that there is a presumption that Len did that with a bad intent. A presumption, and that really means that Len has to prove. What that means is Len has to prove that it was done in good faith, but it's his burden. If he can't do it, he loses. All right. If it's longer than 3 months, then the burden is on the trustee to show that Len did it to try to conceal an asset. So if Len just said, "Here, take title of my car. I'm going to wait 3 months and a week." All right. Well, if that happened and the trustee realized it, then the trustee will have to say, "Well, Len, why'd you give Jim the car?" And that's why Jim's a good guy. Okay, but did Jim give you any money or a note? No, he's just a good guy. Well, the trustee will probably say, well, that's wrong, and you unwind it. Really, a trustee can go and look at any type of transfer as to whether it was done in violation of bankruptcy law. How far you go back, it's really up to the trustee. Typically, they're not going to go back 2-3 years, but on your bankruptcy schedules, you have to identify assets you've transferred sometimes years earlier. Yeah, so you have to be very careful.
Is
Yes.
somebody better off to sell something for a token amount as opposed to just transferring?
Oh yeah, fair market value. What do you think might be? Yeah. Now, if Len and Jim are brothers, all right, family members, then they're called what they call insiders. What that means is you go back a year. So if Len gave to Jim his Porsche, 10 months later filed bankruptcy, then Len would have the burden, or it's a presumption of a fraudulent transfer because it's to an insider within 1 year. And so that would be Len's responsibility. And it's hard to overcome that burden unless you can really show this was a legit transaction. If it's 1 year and 2 months, then the trustee has the responsibility, or at least the burden, to show it was an improper transfer. So, in the context of what we've been talking about, IRAs, the trustee will sit, well, because you're not transferring to a person, you're transferring into something, essentially whatever it might be. And so on the bankruptcy schedules, it talks about transfers of that nature that go back about a year or so, and the trustee just is going to look at those. And most of the time, the trustee realizes and recognizes that as bankruptcy practitioners, we can transfer legally, ethically, morally, under the code, assets that you would lose, and we try to protect those. That's ultimately why one of the reasons why folks hire attorneys, because they don't want to lose anything. So, a good question. So,
I have a question.
yes.
I have a client who went to an attorney, and the attorney found he has on his bank account, it's like the 100,000, and the attorney suggested to move that account to the attorney's trust account so they cannot touch it.
Gotcha. All right, so the issue is an attorney represented a client who's going to, this client was going to file bankruptcy?
I don't remember what's all about.
Oh, okay.
Trust account to his own trust.
Gotcha. So a client had about $100,000, and the attorney said, hey, take your money and put it in my trust account.
They cannot touch it.
Yeah, that's true. Trust accounts for attorneys, basically it's there to hold money that's not yours. I kind of like my bar license.
Right?
And yeah, and so if I have a client that says, hey, can I hide money in your trust account? And I'll say, well, why? And they'll say, well, I want to hide it from somebody. I'll say, no, because I like my bar card. And I work very hard to make sure we make decisions that aren't going to get me in trouble with the state bar. So, yeah, I've had a couple situations where I've had clients approach me with those types of issues, and I explain to them that I'm not the guy for the job. So, good question, though.
If you have an inheritance that's sitting there, would you have to wipe out your inheritance by paying off your debts before you can file, or is that?
Yeah, is it? So yeah, so an inheritance that is yours. Yeah, really, you have to identify all your assets. Now, in that situation, well, I'll take 2 minutes. This is actually a good question. So let's just say you and your husband are married. Your parents unfortunately passed away, but they left you $100,000, and it's in an account that was given to you. All right. And that money is just there earning money. You don't use it for any type of expenses. It's just there. But you have to file bankruptcy. Well, under family law, for the most part, that inheritance money will be what they call separate property. It's not your husband's, it's yours. All right. So if you file bankruptcy, you have to, let's just say you decide to file. Well, in that situation, I would have just your husband file. Because the deal there is when you file bankruptcy, you have to identify your community property estate. All right? And the community property estate is stuff all you got that you have. However, the money in the account isn't your husband's. It's not community property. So what we would do is we want to get rid of all your community property debt. You're not going to file though. And so your separate property would be identified in the bankruptcy documents, but we'll say, hey, judge, can't touch it. It's her money, and she's not filing bankruptcy. And that's the way where the client came with that scenario. We would intentionally have just the husband file, not the spouse.